The views and opinions of guests on this show are not a reflection of the views of the management or staff of this channel. The production of this show is made possible by the support of viewers like you. Please visit conversationsthatmatter.tv and become a subscriber. Welcome to Conversations. Our objective each week is to have an in-depth conversation with a thought leader on one of the major issues that is going to shape the future of British Columbia over the next few decades. Joining me right now is correspondent Mike McNish to talk about who our guest is today and their perspective. Today we have Gordon Gibson on as our guest. Tell us a little bit about Mr. Gibson.
Stu, Gordon Gibson has been at the heart of the whole question of what is democracy in Canada for almost 50 years. He was an assistant to the Prime Minister, Pierre Trudeau, in the late 60s, then came home, was an MLA, and leader of the BC Liberal Party. And he's really been someone laser focused on this whole notion of what is our Canadian federation, what does that mean as a democracy, and how do First Nations fit into our federation here in Canada. And he has some very interesting thoughts, of course, on the Williams or Tsilhqot'in case, which has upended the apple cart, as it were, on First Nations land rights and land claims. He penned an op-ed, as we know, in the Globe and Mail shortly after the decision that got some eyebrows raised. And in the op-ed, he was very clear that he lays the blame for any problems we're having vis-a-vis land claims at the foot of the provincial government and the federal government. Now, he says the provincial government has come a long way and is improving its relations with First Nations. But in his words, he says the feds are really still in the dark ages. So it'll be a very interesting conversation for sure.
He also says this is no small matter. This is a big deal. The landscape has changed.
That's right, Stu, because the Williams decision gives the First Nations not only the claim to their historic lands, and by that we're looking way back at their traditional hunting and fishing lands, as well as lands that they've traversed over as nomadic peoples for years and years and years. So no one's really sure geographically how much of British Columbia are we talking about. There are estimates from 50% to 100%. But it's big in that way. How much of British Columbia will now become autonomous First Nations land, that the First Nations will decide how the land is used, how they will economically benefit from it, and how it will be managed for years and years to come. It's a very complicated and fascinating conversation. I'm sure Gordon Gibson will have some wonderful insights.
Well, on that note, let's go to that conversation that we recorded here at La Cigale Restaurant on August the 18th. Welcome, Gordon. Thanks for joining me on this very interesting topic with divergent points of view. You are sounding the alarm bells around the Tsilhqot'in decision. How come? What is it about this decision that makes you go, this is a big problem? And then once you tell me that, then let's go back and take a look at the steps that got us to this point.
I'd like to go back to the start, because this is not out of the blue. This is 400 years of history that's brought us to this point. What the Tsilhqot'in decision has done is awarded roughly 1,700 square kilometers of so-called Aboriginal title to a very small band, about 200 members. What it foreshadows is the possibility that much, much more of British Columbia will be found to be Aboriginal title. Now, up until now, people who wanted to do anything as simple as renewing a lease in what was called claimed traditional territories had to take into account the Indian wish, as ordered by the courts, to be consulted and accommodated. So what does this mean? Nobody quite knows. Sometimes it means nothing, sometimes it means some cash changes hands, but generally in the end you get it done, unless there's a whole lot of protesting going on. Now, what Aboriginal title means is not consultation and accommodation. It means consent or veto. This is my land. And incidentally, this is not only my land, but it's better than your land, because your land the government can expropriate, and my land they can't expropriate. They can, in certain circumstances, infringe upon it. However, nobody knows what that means, and I don't think it means very much. And
It's going to take another court case to solve that.
It's certainly going to take another court case to solve that. And an interesting thing to remember, this is a big province. And the people who settled here first naturally settled in the very best parts of the province. The lovely beaches, the good coastal resource areas, the interior valleys, the communications routes. That is where Aboriginal title is going to be found. And in my opinion, there's going to be a lot of it. So this is going to have enormous consequences for everybody in British Columbia, the Indians and the rest of us. And our challenge is going to be to try and make it a win-win.
How do we do that, though, when we now say this is your property and you are a distinct society on your own land, you're an island within British Columbia? How do we make this a win-win?
Well, as the Supreme Court said in Delgamuukw, one of the seminal cases we may come to talk about, let's face it, we're all here to stay.
Right.
We are.
Okay, under that umbrella, let's say I'm a forestry company and I now go, okay, you kicked that forestry company out, which led to this decision, but we want to come in and we want to work out a deal with you. Who do I negotiate with?
It will be very site-specific. Then the first thing you will do is hire yourself a good lawyer and a good consultant, and then get on the ground yourself if you're smart and get around and talk to a lot of people. So that's the first thing you want to do, and then of course you've got to keep the government informed, and the government will say, have you talked to the Indians? In which they stand the Supreme Court on its head, because the Supreme Court has made it quite clear in the Haida decision, for example, the relationship with the rights and title of Indian organizations is one that has to be dealt with by the Crown. It is the responsibility, the honor of the Crown insists it is government responsibility to take the lead in these relationships. And the government, both governments, the feds and the province, have shamelessly offloaded this onto private proponents who are not equipped to do this, I presume because they want to save money. And the provincial government, even 2 or 3 years ago, shut down what is called its Strength of Claim Department, which was a group which was supposed to assess. Many Indian organizations have overlapping claims throughout the province. So one of the things to try and understand is who has the best claim in this particular hectare of land. Well, they shut this down. They're going to have to reinvigorate this awfully quickly now that this title decision's come along.
So as we move forward from this decision, which is at this point about 8 weeks ago, and we start to make sense of it, how difficult do you think is it going to be for an individual company to say, I want to be able to draw on the resources of that land and work out a deal?
Well, short answer is the more money you got, the easier the deal's going to be, that's for sure. That's in a way too glib an answer. The first question is going to be relationship and respect, because this means a whole lot to all human beings. So you want to be on the ground, you want to be talking to people. But Tsilhqot'in has raised so many questions. Governments and businesses are downplaying these questions because they don't want to give rise to uncertainty. And I'm sorry to be pointing this out, but there's a huge amount of uncertainty in the wake of this decision. Several of the Indian spokesmen have called it a game changer. They are far closer to being right than the government, which is saying, you know, this is just an extension of Delgamuukw. Anybody who says that doesn't understand the difference between a feather duster and a hammer. And the old consultation and accommodation was closer to a feather duster, and Aboriginal title, that is a hammer. I own this land.
Well, that is one of the differences also between Tsilhqot'in and Delgamuukw. In Delgamuukw, they're acknowledged as having a legitimate claim, but still the treaty isn't signed when you go to the Gibson. Here, they've been given title to the land. So that in itself is different. So how can it be that we're talking apples to apples? We're talking about a different situation altogether.
Well, one of the great debates at the moment is land certainty in British Columbia going to come about through litigation and title, or is it going to come about through treaty? And there are arguments both sides. Treaty is very difficult. I had really the honor of sitting on the Gibson side of the table negotiating treaty with Canada and British Columbia for 4 years. Mm-hmm. And the offer that at least the particular group of Gitxsan chiefs that I worked for put on the table was so unbelievably reasonable. We always want to be Gitxsan, but we don't want to be Indians anymore. You guys made us Indians. We didn't want to be Indians. We want to stop being Indians. We don't want any more of your money. We don't want our own government. You guys know how to run governments, and we'll participate in elections. But what we want is our share of the resources on our territory. This was marvelously generous of the Gitxsan, I thought. Governments wouldn't talk to us about it.
They wouldn't entertain it?
They were literally not allowed to talk to us in substantive terms because this was not within their mandate. This was a new idea. And new ideas in the Aboriginal departments of government are not things that are looked on with great friendliness, though they're going to have to be today because they've got to have them.
Well, they're going to be forced to. Grand Chief Stuart said, I don't want to participate in the treaty process. We don't get anywhere near as much out of the treaty process as we do from the courts. And so the Tsilhqot'in decision really starts to become a blueprint for the way forward, in light of the fact that the Treaty Commission is all but stalled, if not dead.
Well, Stuart Phillip may or may not be right in the end, and I suspect it, again, will depend on particular circumstances. One of the difficulties for Indian bands or nations with the court process trying to get title is the Supreme Court of Canada insists that to get title you must prove exclusivity. Mm-hmm. In other words, that you controlled this area and repelled anybody else who tried to take it, or if you let them in, it was because you had allowed them in, not because they had forced their way in. Now, British Columbia is a seething mass of overlapping land claims. So to the extent that the various organizations maintain those land claims, they will almost be admitting in court that, I guess exclusivity wasn't there. So I suspect what will happen is there will be a lot of sorting out of overlapping claims, and people will pull their horns back a bit and say, okay, we're satisfied with this area and you take that area and that'll run fine. And if that does come into effect, that kind of cooperation comes into effect and is accepted by the courts as bona fide, then you could have quite a few title decisions coming down. On the other hand, if the overlapping claims are not well managed, then you're still going to be relying on the treaty process, but governments are going to have to be much more forthcoming in the things they'll talk about. As I say, I sat on this table for 4 years. I am absolutely prepared to say without hesitation the governments were not negotiating in good faith. And that's the first thing you have to have in a negotiation. Now, to the credit of British Columbia, in the last few years, they've been making one-off deals individually around the province, a bit of a royalty share here and this and that there. And so they've been making incremental progress, and that's good. But until you have these treaties, you're really not going to get the kind of certainty that investors from around the world are looking for.
If the economic benefit of tidal lands only goes to the band, it's going to have a tremendous impact on provincial budgets.
Well, it will anyway, even if there's taxation possible. And we don't know if there will be. That could go to court too. There's so many other questions. How much Aboriginal tidal land is there? I'd love to see an estimate from the provincial government on this. They must be at least scrambling to get one, but is it a quarter of the province? Is it best 10% of the province, or is it something more or less? I don't know. Can resource royalties be charged by the province on timber and minerals? Almost certainly not. Can the land itself be subject to property taxation? Probably not.
Probably not.
Probably not. What about compensation for timber taken off that land for the past century? Do I, as an Indian nation, have a claim for compensation for that land for that timber that was taken off what was my title?
It's a legitimate question.
It is, and the court did not answer it. It can be argued one way or another. They said that title only vests when it's defined, but on the other hand, what happened before that, we don't know. What about private lands in areas that are subject to Aboriginal title?
Wasn't there some distinction, though, that said when there is private land, that will not fall within like the title claim, that private lands now are taken off the table?
In the Tsilhqot'in case, the plaintiff said, we explicitly exclude from this case the few parcels of private land in our territory. And I understand why they did that. They did not need that problem.
Yeah.
They're tiny little parcels of land. The Indian leadership in British Columbia has always said private land is off the table. I would say that too. I don't want to fight a war, which would be a nuclear war, until I'm ready to do it. But the courts never said private land is off the table. Now, I was talking to a friend a couple of days ago who had to renew a lease on a small water lot. He was told by the government he couldn't renew the lease till he paid the Indian Nation concerned $1,000. That was the government's view of that one. Where did that come from? What happens when the leased land, the municipally owned, in other words, government-owned, leased land in False Creek comes up for renewal? What will happen to those lease renewals? I don't know.
Nobody knows at this point.
Nobody knows, but it would be a good thing to be asking the questions. I don't know if the court ever thought about these things.
As you have pointed out, we're looking at hundreds of thousands of people over the last couple hundred years who have been treated atrociously by the government of Canada. And one part of you goes, okay, you're getting what is due to you. But at what price? How do we define what that price is to all involved? Because as was pointed out in Delgamuukw and also in the Tsilhqot'in decision, no one's going anywhere.
Yeah, the Delgamuukw, when it came down, it effectively paralyzed all the treaty negotiations that were under the way. Well, Tsilhqot'in is a bit the same, and as we were mentioning a moment ago, it's going to confuse the question of whether people should go to the courts or whether they should go through the treaty-making process. And only time, and I'm afraid a lot of court cases are going to sort that out. Now, if we can get on both sides the kind of leadership that says, you know, we regret the past for all kinds of reasons, whether we've been harmed by it or whether we did it. And we want to talk now about the future instead. And how can we make this so that we all win? As again, the Supreme Court said in Gladstone, a case in the middle 90s, it's part of an economic reality, and it's got to work. But on the other hand, exactly how did this work? If I'm a band or nation along the LNG pipeline route, and I get a declaration of Aboriginal title, I can do a lot with that. And I might say, well, what I would like, you know, it's not unreasonable, I'd like 1/2% of the value of that gas going through there. Not an unreasonable thing. Add a few of those up, all the economic rent the province thought it had is gone. Now, is that right or not? So there's a new power relationship here. And it has to take very sensitive people on both sides of the table that will sort that out in a way that, in the end, in a way that will stick in two places. In the minds of the people as to what's fair, and in the minds of the court. And these two things will interplay among themselves. And the challenge for policymakers is to do this quickly. It'll all work out in the end, but you could sure put a damper on the economy of this province for the next 20 years while the courts are working it out.
Well, you were talking about reconciliation. How do we bring two groups together in a way and put the past behind us? That's going to be a painful process in itself. I'm not convinced that the Truth and Reconciliation Commission is going to get there, especially when you consider that perpetrators didn't come to the commission and say, yes, we were there and we committed these atrocities. And they didn't do it because who would, when the commission didn't have the authority to be able to pardon them for their participation in this. You know, a lot of people will want to say, well, I'm done with the past, let's move on, but the past may not be done with us, and so we need to get through that hurt.
You're absolutely right. That's a very human feeling.
If we're going to be able to work together.
Yeah, and it takes, it takes Nelson Mandela-like people, few like him, but it takes that kind of approach to get past it. And if you don't get past it, you're going to prolong the misery.
As you look down the road over the next 10 years, you are looking at a bumpy road, aren't you?
Again, it depends on leadership. Now, I mentioned earlier on that the court explicitly has given governments the right to, quotes, infringe, quotes, on Aboriginal title lands for valid public purposes. We don't know what that means. Is this something that could be handled by let's say, a new law that says this is how we are going to consult and this is how we are going to compensate, and as long as you do that, you can build that pipeline? Or will it be a much fuzzier thing that will be, well, you know, we're going to sit here for the next 5 years and litigate, and you just watch what happens while the natural gas sales window closes in Asia. Which way is it going to go? That's going to depend on leadership, which makes me worry a bit.
On all sides of
Leadership
the equation.
on all sides of the table.
And it's not just provincial, Aboriginal, but there's also the federal government that's involved in this
There's
as
the federal
well, 'cause we
government
can't
there.
do it without them.
And there's also business leadership, though, as I say, they're being asked to accept a burden that they shouldn't be because governments aren't doing their job.
And we have to pay attention to it. But it's not being paid very close attention to. There's always happening over there.
You don't know. As I said, I understand why the province would be downpedaling this and saying, oh, it's not a big emergency, because the province wants to attract investment from around the world. So it's not to their advantage, nor probably not to anybody's advantage, to say, oh, this is terrible. I don't know what's going to happen here now. On the other hand, whatever they say for the public record, they should be saying inside the government, my gosh, this is something that's got to have all our time and attention. This has got to be job number one. And
you maintain that we also need to know that, the people who call this province home.
Oh, yes.
Yeah.
Oh, yeah, because it's, as long as our leaders are saying this is no big deal, okay, I'll go buy another beer or whatever I do.
Right. Well, thank you. Thank you very much.
Thank you, Stuart.
Yeah.
And you're entitled to mention my book.